Welcome back to DBS and the DFL studio. Tonight we're talking about the laws of succession. We're talking about wills, why we should have one, how to get them done, and the repercussions of not having a will. But before I talk to my guest, here's a quick reminder of giveaways tonight. Organica will give away organic millet rice cereal, fruit juice, and a packet of stone ground whole wheat flour if you can tell us how long Organica has been open. You can also win your choice of creamy, lovely Fairens ice cream if you just tell us what your favorite color is. Simple. As we continue to promote local artists, we feature a painting by Elsina Noli entitled Moving House. You will see Noli's colorful interpretation of a broken down chattel house. And you know what? She's also at the expo that we spoke about earlier. So go down there and you'll see Elsina's work. Let's go to the meat of the show now. Veronica, tell us a bit about yourself, your practice, and anything you'd like to tell us.
Thank you, Delia. I have, well, as an attorney at law, my practice is a general practice. I've been practicing for the last 15 years in St. Lucia. Quite a bit of those years has been practiced in the government of St. Lucia as an attorney in the Attorney General's chambers. I've also had experience in international regional organizations with the OECS, and now I run my my practice located in the Rodney Bay area. I have to say the topic tonight is something that is very close to my heart. Successions is one of those areas that I started in when I just started practicing. I practiced with my cousin Dexter Theodore, and I did a lot of matters for my late grandfather, Mr. Winston Cenac, QC. And quite a bit of them were actually on land, property issues, and much of it around succession, partition actions, etc. And unfortunately, I think in St. Lucia, we still at a point where we don't really appreciate the necessity of having wills and the complications and confusions that can arise as a result of not having a will and not dealing with your estate in a way that makes it easier and legal after your death, because your intentions is not something that persons can read into. Your intentions ought to be clearly set out in a document. Don't leave it for family members or one or two individuals to say, well, that is the intention. It never works.
And definitely, viewers, we are going to be touching on all these things tonight. So if you're sitting there thinking, I'm one of those people, you need to just sit at that seat and you need to take in the things that we're going to be discussing tonight. Andrea, tell us a bit about yourself, please.
Yes, well, I'm a little different to Veronica. First of all, I'm a chartered accountant. I'm also a fraud examiner and a chartered corporate secretary and administrator, among some of the little things that I won't go into right now. My actual preference in terms of practice is in the corporate area, but I'm very interested in the law of succession. I actually did my first will when I was about 19, you know, and I always have a difficulty with people who think that, you know, if you prepare a will, it's because, hey, I'm going to die. Some people just dread just discussing a will. And I know we have quite a few people out there who do not have a will because, one, they don't want to discuss it. They have the fear of dying. For some reason, people think that when you talk about will, it's because you think that they're about to die.
That's right.
And so people, but I actually like that area of practice. And it's an area that I would like to spend a lot of attention, pay attention to as well into the future, because I think it seems to be a little lucrative as well, which is an incentive, you know.
Okay, well, Veronica's smiling.
The accountant that you are.
But I mean, I love the mix of both of you here, because I mean, I have done a program with Veronica on the very same thing, and as I said, the phones just would not, you know, stop ringing, because obviously Veronica knows she's been in this for such a long time, and in us talking and you being here as well, you see the other side of the fence.
Correct. That's
you know,
correct. That's
and you'd be able to show other people, because they may be thinking, oh, this is not really me, but then I think you will come up with something that they'll say, oh yes, that's me, I'm in that situation.
But I also think that this is such an important area that you think at school they should be introducing, you know, at least a limited knowledge on, you know, educating people with respect to some of the issues that arise from succession.
So when we say a will, then what in your words is a will?
Well, a will is basically a revocable declaration in that it can be revoked sometime into the future.
Revoke.
Revoke.
Yeah, revoke. I mean, I'm asking you, simplify that to some people who may not understand what revoke is.
You can change your mind with respect to whatever, you know, in decisions that you have indicated in the will. And basically, it somehow puts together the wishes of the individual, usually who is making the will, generally referred to as the testator, and the disposition under that will generally take effect when the person dies. So it's really in contemplation of death, so to speak. That is when it will, it will generally take effect, the will itself, whatever is in that will. The truth is that you have different types of wills. In our jurisdiction, the more familiar ones would be the notarial wills as well as the holograph wills. Most people are of the impression that you have to go to a lawyer to get a will done, and that's not true. You can actually prepare a will in your own handwriting, and it is referred to as a holograph will. And that will, you have to sign it. It does not have to be witnessed.
I didn't know that.
Yeah.
I thought that you had to have it witnessed, or you at least had to go to a notary to sign that.
No,
But it must be in your own handwriting.
It must be your own handwriting. And generally speaking, when you come to the situation where you have to probate that will, for example, you'd probably require someone who is familiar with your handwriting to at least say, yes, I acknowledge that, some sort of affidavit saying, yes, I acknowledge that this is the handwriting of the individual who prepared the will. You also have the notarial wills, right? In which case you would require it to be witnessed in the presence of 2 attorneys.
Yes.
Or you could have 1 attorney and 2 witnesses. And you also have to be careful with respect to the witnesses, because if you stand to benefit under the will, you should not be a witness.
Okay.
Because that will be void. That aspect of the will will be void. So if somebody is going to bequeath some property to you, please do not be a witness to that will.
Okay.
That element of the will be void.
Okay. Well,
And there's one more form, the English will.
The English will, I'm not too sure how popular that will is over
Oh,
here.
Veronica,
But it is recognized in our law, under the Civil Code, which basically encapsulates almost all of our law relating to succession. The English will is a will which can be typed up, but it is witnessed by one individual and a JP. Right? So that's the 3 wills that we recognize. The holograph will, you can sit and you write your own will. The
that one's been
notarial
kept
will,
very quiet, because we've had a lot of questions before the program started saying, why do we have to go to a lawyer to get a will? Why can't we do it on our own?
But the truth is that you also have to be careful.
Yes.
Because the way the will is worded can give rise to issues subsequently. So the wording, the actual wording of the will is very important. This is where you might need the help of a lawyer. So if you're not where you do not have, significant property to dispense with, then you can do it in your own handwriting. But when it comes to a situation where you have material assets, I think you should consult with an attorney.
Yeah.
Okay, well, I've learnt a lot there, but I want to go into the other definition, which is a bigger one in terms of, we've been saying we're going to discuss tonight the laws of succession.
Right.
Veronica, can I ask you to enlighten us?
Succession, is an area of law that generally deals with the estate of a deceased person, right? It encapsulates both in terms of the what constitutes the estate of that person and how that estate can be dealt with in accordance with the law.
Now, when you say estate, because I just want to clarify for our viewers, estate doesn't necessarily mean some land.
No, it means movable property, which can be things. It can be furniture, it can be jewelry, money in a bank, etc., shares in a company, and it can be immovable property, which is land, immovable property, which is land,
Land buildings.
land buildings, etc. So the estate can encompass all of those things. Your interests, for example, in intellectual property, rights, etc. All that is part of your estate. So succession is the area of law that determines how your property is to be dealt with and how the law steps in to deal with it. And in terms of your estate, you have two scenarios. You have a situation where someone dies intestate, in other words, without leaving a will, and someone dies testate, where there is a will. If there is a will, the will takes precedence as to how your property is to be dealt with. If there is not a will, then the law steps in to decide, to determine how it is going to be dealt with.
Wow.
And that is our laws of succession, especially intestate successions in St. Lucia. It's not just complicated, but it's actually, some people might say it's a little ancient, right? We still have very old references to issue, for example, instead of children.
Yes.
You're not a child, you're an
old,
issue.
Yes, it's Old English. It's
That's right.
more advanced. It can be a little
and
difficult.
also we do not recognize many things that are now in other jurisdictions well recognized. So we do not recognize common law relationships. So spouses of in a common law relationship cannot inherit from each other in St. Lucia. And children can inherit from a mother who is not married. So if the child is illegitimate, and we still have the word illegitimate in our law, if a child is illegitimate, then they can inherit from the mother. But you may not be able to inherit from the father if the father is not a single man as defined in law. And Article 579 of the Civil Code defines a single man as a man who has never been married.
Right. And it's a little different.
Right, okay. You know what? My head is hurting me. My head is hurting me because that is a lot. Those few words you said, I'm sure a lot of our viewers are like trying to sink that one in. So we're going to go to a break. And when we come back, I actually want you to repeat that because I think that a lot of us out there, that is kind of strange to us. I think we need to kind of just say that one more time to make it clear to the viewers out there what Veronica just said, because a lot of you are going to be hurt if you don't listen to this. This is Dolor Factor Live on DBS. We'll be right back after this break. Stay with us.